Welcome to Environmental Law course, dear learner and viewer. Today we are going to deliver our lecture on environmental policy in historical perspective. Environmental policy in historical perspective in India is a very interesting discourse because it deals with partly the colonial law and the laws or indigenous law and the customary law. The combining of the colonial law and the customary law in matters of the environmental policy in India is very innovative in the sense that it gives rise to see many cross-current in the jurisprudential plane. We start the entire discussion of the environmental policy in historical perspective from the forest because the forest symbolizes the colonial legislation and the colonial legacy of the Indian law. The forest right, which has been perceived by the Britishers, is very contesting discourse because the rights which emerged out of the forest was the right of the colonial master. The British forestry, in this sense, we find that emerged after the Indian Forest Act and regulation, which has been handed down by the Britishers in 1865 and 1878, and after that, it assumed a very comprehensive law in 1927. In this lecture, dear learner and viewer, we will try to see the same broad perspective and the major cross currents of the colonial environmental policy and law in the historical perspective, that too of the modern Indian history. First and the foremost, that it deals and touches upon the forest conservation and the forest right and the forest inspection. Then it talks about the conservation agenda of many of the habitats which were prevalent in Indian subcontinent, that is leading to the forest, leading to the wildlife, leading to the pastures, leading to the prairies, leading to the grazing field, and how the Britishers have adopted and honed out their conservation agenda to serve the imperial interest and as well as the interest of the aesthetics and the environment. The colonial history in this country, which have massive evidences of the environmental conservation and the environmental policies, can also be looked from the forestry policy in the colonial India, especially the Eastern India, by the mechanism of the customary law. In this, the very interesting aspect of the historical evidences and facts we have gathered from the Eastern India, that is Chotanagpur area, where there has been a tribal movement and the tribal custom with the local administration, how they have infused the tribal rights and customary right with the reservation of the forest law, and how they have prioritized the extraction of the revenue and extraction of the forest produce, extraction of the forest resources, and in that colonial desire of extraction of the natural resources from the forest, how they have devoted to the question and addressed to the question of the interest of the tribal people and their assumption and assertion of the customary rights and the law. The historical perspective, the environmental policy in historical perspective can also be viewed from the lens of the water right and the riparian rights which the colonial India have claimed in matters of separated land and the water sharing and water distribution for the revenue purposes. In this context, we see across India, right from the South India to the North India, to the Central India, the Eastern India, and the Western India, the Britishers have devolved large number of the policies and the legislation and statute to determine that what are the water rights and the riparian rights and Jamabandi system and the Warbandi system and the customary rights of the water resource management. In the historical environmental policy and historical perspective in India, we will also try to reflect upon the aspect of the introduction of the environmental law and the environmental history. We will try to see that how environmental history and all the environmental historical studies have try to see the entire environmental law and legislation from the point of view of the human interaction and the nature over the period of time. The study of environmental law and the legal history in India is very interesting in the sense it tries to see the environmental law in the legal history perspective from an angle whereby the human interaction and nature over the time have a conflicting kind of the model of interest into the administrative and as well as the economic. Whereas in the entire annals of the environmental history and the entire annals of the environmental and legal history, we find that the nature has been a kind of the entitlement of the people, but how the colonial masters, having their imperial ambition, try to convert the nature into an administrative and economic tool. Thereby, what we see that the environmental history and the environmental laws combining together have introduced certain regulation which try to regulate the forest, water, and the mineral resources. Each and every aspect of the colonialism, imperialism, has been taken into recourse on the natural wealth and the natural resources in India. It tries to see that how best the colonial master to serve the industrial revolution in England have tried to prioritize massive depletion of the resources and maximization of the revenue and extraction of the raw materials to fill the needs of the industrial revolution in England. Therefore, it is not surprising that what we see in the post-pre-colonial India that is a kind of an environmental history and the legal history of plunder and then try to see some of the environmental resources on the extinction. In the post-colonial India have continued the same colonial legacy in the entire spectrum of the environmental laws and policy, subsiding, marginalizing the indigenous and rural communities, and they continues to lose their resource right which they were enjoyed since time immemorial and which they have the rights without any kind of explicit recognition by any law. The Indian people, Indian farmers, Indian conservers, Indian tribals were already exercising that right to forest resources, that right to environmental resources. How the entire colonial policy and law have altered the very fundamentals of the entitlement of the environmental resources. Therefore, when we talk about the introduction and overview of the environmental law as well as the environmental history in the parlance of the colonialism, imperialism, then what we find that it is a kind of a study which is full of the clash of interest, which is full of environmental conflict, which is full of human and nature conflict, and these historical foundations are palpable and discernible in the entire range and policies which the British India has promoted in matters of forest, water, mineral resources, fisheries, and other sectors of the environment. Therefore, what we see that the environmental law and the history must be understood when we try to engage into any kind of a discussion on the environmental law in India because it serves as one of the basic document, it serves as one of the basic orientation to underline the priorities of the environment, the priorities of the ecology, the priorities of the state, the priorities of the governance, the priorities of the people. The theoretical framework of the environmental legal history in India is to be understood within the framework of the law, state, and the nature. Here, the law became instrument of environmental and political control, and therefore, law which has been seen only as a kind of a symbol and a metaphor of the power in a political parlance, but we see that this power and the political supremacy of the Britishers in this country have directly invaded the entire environmental resources, and therefore all the policies which the colonial India has pursued in this period is an instrument of environmental exploitation and depletion. It came very heavily on the notion of the state property and as well as the common property. And whatever the common property resources were available to the people in general for their entitlement and for their betterment have been continuously encroached upon by the state's lethal and aggressive control over the natural resource as a property, assuming that all natural resources and nature under its powerful imperial ambition and the colonial ambition became a state property. Certainly, the wiping off the common property resources and then assuming all natural resources as a state property to serve the political end and administrative control have set at naught the customary local rights which the people were enjoying since centuries and since time immemorial in the Indian subcontinent. All the customary local rights which were mostly unwritten, mostly traditional, mostly passed through generation to generation, have resulted into the codification of those rights into the legal statutes and regulations. The massive codifications of legal rights setting at margin to the customary rights encroached not only forest, but it encroached upon the rivers, it encroached upon the land, and forests, rivers, land, and all major environmental and natural entities came under the massive bureaucratic control and ownership of in the colonial India. Therefore, when we have any kind of a discussion relating to environmental policy and historical perspective in India, we must start from the point that the modern environmental law, which originated from colonial governance and the colonial set of interest, the colonial mindset of looking the nature as a sector of economy more and not a sector of the ecology by pursuing the policy of exploitation, extraction and transfer and drain of wealth theory in the colonial India. Therefore, what the laws which have been handed down by the colonial masters in British India and the sum total of the entire environmental statutes ostensibly appears to give rise to recognition to customary local right, but in reality have tightened their control and bureaucratic overlapping by the Britishers, and that policy unintentionally remained continued even after India's strife with destiny in 1947 and Indian independence. The entire policy of the colonial environmental legal history permeated in the entire developmental process and the environmental statutes. Therefore, the law which has been shaped in colonial India by the state have addressed the question of nature and the entity of the nature as more of an ecological relationship and socio-economic hierarchies which are being subsided by more bureaucratic control and more bureaucratic kind of the control and more regulation and codification of the rights. Thus, we see that the entire notion of environmental justice and the resource conflict in the colonial India links ecology with human right, but colonial laws taken environmental resources as the privilege of the elites, and then it was dramatically and silently transferred to the corporation over the interest by subsiding and marginalizing the interest of the local communities. This kind of a alteration in the environmental justice and human right to ecology, which were already in practice in India by the colonial laws, set a sense of alienation and the sense of belongingness of the people, which were intact in the historical periods prior to the modern Indian history and the colonial India, have been altered by a sense of alienation. And that sense of alienation was done by the permanent settlement, which tries to replace the peasant and Adivasis from their right of tilling the soil, and the son of the soil, who happens to have unbridled right over the land, they feel very suffocated and they feel very alienated by the permanent settlement of the colonial India and the Britishers. Most of the development project after the permanent settlement of the displacement or the massive displacement of the peasant and the peasantry rights and the customary right of the Adivasi deepened a sense of not only alienation but discrimination and inequality. At the same time, the entire policy have created a severe ecological damages in the colonial India. That's why we have to see from the standpoint of view of the colonial sets of environmental laws into the policies of the Britishers, that how the question of environmental justice have been reduced to a kind of a resource conflict. And that's why it is not surprising to see in the colonial period the popular ecological movement like Chipko movement, Narmada Bachao, which have revived all kind of the struggles against the state by their repressive and lethal policies against the environment. The struggle of the people continued for assertion of the customary law being a legal foundation for their resistance and their entitlement. Therefore, the modern sense of environmental justice, which creates a framework and which talks of equity and sustainability, seems conspicuously missing in colonial period. Now, the same policy which have been continued govern the entire forest, govern the rivers, governs the grazing field, governs the agricultural lands, governs the peasantry rights. These rights were not individualistic in historical annals of Indian environmental history and Indian environmental law, but these rights were communal rights. These rights were community rights. These rights were collective rights, which emphasize on sustainability and reciprocity, use and nurture the entire environment and the nature. But law has been taken an instrument of environmental resource exploitations by the Britishers, and their codification transformed these inalienable rights as a mercy of the estate, a kind of a concession by the estate. This has set the tribal and village rights systematically being eroded and erased from the legal landscape. In this context, we can buttress our point by citing the popular rebellion of Birsa Munda in 1895 to 19, which resisted this kind of the aggressive policies which have wiped out the customary rights and has given a popular movement at the grassroots level for more autonomy and more traditional resources and entitlement. The colonial forestry and the conservation policy has led the fears of famine and desiccation. And we see that in colonial India, not only the people lived in a very abject poverty, but there has been great occurrences of the famine. The famine, in fact, symbolizes the shortfalls and the myopic perception of the colonial India in matters of the environment, in matters of the natural resources, and the utter failure of the control of the state, colonial state, of all the natural resources, diminished people's entitlement, and they move from poverty to penury, and they move from food scarcity to famine. And then, in the name of scientific forestry, which has been introduced in British India, it was a clock, it was a kind of a facade, it was a kind of a euphoria for the people. In fact, before the scientific forestry of the Britishers, the idea was to have sustained timber extraction for shipbuilding industry in England, for World War I and World War II, and introduction of railways, shipbuilding, and two world wars created a massive demand of the timber, and that massive demand of the timber is being carried out by systematic destruction of India's forest. Indian Forest Department was separately created in 1864 to regulate the forest resources. The Forest Regulation of 1865 and 1878 institutionalized complete monopolization over the forest resources. All the forest acts was not an act for the forest conservation, but all the regulations and the forest bureaucracy which has been created by the Britishers in India in 1864. Subsequent to that, the Forest Regulation of 1865, Forest Regulation of 1878 culminated into a kind of a policy of extraction and exploitation of the forest resources. Forest become a metaphor of power. And it symbolized political and ecological domination. The net effect of the monopolization of the forest, assuming as a political power, assuming as ecological dominance, then the result of all these escaped approach of the forest policies and laws has been that the local livelihood, the cultural rights of the people towards the forest were put into the margin. they were alienated, and most of the time they are criminalized by a powerful bureaucracy of the forest, Indian Forest Servant and the Indian Forest Services. Indian Forest Act 1878 divided forest into three categories: reserved, protected, and village. In the reserve forest, complete sanitization of the local communities. In protected forest, they have a very limited sense of rights, and it put all the settlements of the claims pending. In village forest, a symbolic rights and nominal rights were conferred and given to the community, that too by a state regulation. Thus, customary rights were replaced by the sense of discretion and concession of the estate, and the forest department gained unbridled power over the land use, and this have been more fortified into the Forest Act 1978 2027, which is a very exhaustive law, is still in force in independent India as a living reminder of the colonial policy, colonial law, and represent the entire environmental and legal history in India. Though there has been many tribal resistance and popular movement, as has been mentioned earlier by the Birsa Munda movement, which was primarily because the tribal community in Jharkhand sensed that this kind of a policy of the Britishers is not only encroaching upon the forest, but it is equally going to have the reducing the peasantry right and the tenancy right. The promulgation and codification of Chota Nagpur Tenancy Act 1908 recognized limited right. Then from forest it moved to peasantry, it moves to tenancy, and then it given more impetus to tribal struggle for their ecological right and a political economy which is deeply rooted into India's environmental history as a history of a struggle, history of resistance. Colonial India's forestry in eastern India have created forests in Chota Nagpur which were reserved. Then is a very detailed report was furnished by the British India and the colonial India, that is known as the Macpherson's 1900 study, which have very unequivocally defended the community right over the forest despite the novel findings and recommendations of Macpherson report. The local people, their legitimate entitlement, particularly in the area of the Jharkhand, Purahat and Saranda, which reflected the competing claims of the people and the state, resulted in stifling the rights of the tribal people, and the forest and the colonial forestry in East India became a site of resource extraction and as well as the resistance of the people. The colonial water policy across the India have been regulated by Madras Irrigation Cess Act in 1865, North India Canal and Drainage Act 1873, and Urlam Zamindari case 1917, which marginally upheld the traditional riparian right. Otherwise, two massive major enactment, Madras Irrigation Cess Act 1865 and North India Canal and Drainage, claimed a sense of ownership over the rivers, canals, waters, and irrigation. Thus, we see the state after the forest and the forestry encroached upon the rivers as an asset of taxation and control. It also tried to dam the river by their engineering work for colonial profit, and it ignored many times the ecological interdependence and the local governance, which they have a very pivotal role in India's water resource management and traditional water harvesting system. That has been drastically and substantially ignored by the colonial water policy. The post colonial water governance is continuing in the same way, which has been reflected into a very comprehensive enactment known as Indian Easement Act 1882, which recognized riparian rights in a very limited sense. Although the Constitution of India under a state list entry 17 mentions about the water, then the public trust doctrine, which emerged in 1990 through the court's ruling, which make a state as a trustee of the natural resources of public welfare, and it tries to see that water resources are not a kind of a state monopoly, but it is the entitlement of the common people, which must have water equity as well as the quality, and as well as the people has a right to see all the pristine glory of the water to gush and flow in a sustainable manner, and there should be a very judicious water resource management in the country. With this, what we feel out of the discussion about the environmental policy in historical perspective in India as a very testing case to study not only the colonial law, not only the environmental law, not only the environmental policy, not only the environmental history. This aspect is a confluence of the legal history, and the legal history of the environment in India can be better studied and critically studied in terms of its environmental policies and law, which spread across the forest, which spread over the irrigation, which is spread over the rivers, which is spread over the overall monopolization of natural resources, commercialization of the natural resources, extraction of the natural resources, creating a very heavy toll on the rights and entitlement of the people, and throwing people from their land, stifling peasantry rights, stifling grazing rights, stifling customary rights, and then the repressive and lethal policies of the colonial India in terms of environment and law have resulted in the rise of many popular movement and resistance and a struggle that serves as an eye-opener to see that how post-colonial environmental law should get out of the yoke, pail, and pounds of the colonial hangover and the legacy, and we can refurbish and reframe our environmental laws, taking major clue from the historical resistance and the rights enjoyed by the people in terms of environment into the modern environmental law in post-independent India. With this, dear learner and viewer, I wish to thanks and I also wish you to happy learning.